How does this principle affect federal tax law interpretation? When interpreting federal tax statutes, one must examine which entities and locations are expressly named. If your state is not one of them, and there is no statute expressly expanding the definition to include it, then the statute cannot be lawfully applied within that state. Congress has demonstrated that it knows how to define United States to include the 50 states. See IRC Section 4612A, 4A. Where such language is absent, courts may not presume inclusion. Doing so would constitute judicial legislation and a breach of the separation of powers. In what other ways is the Internal Revenue Code deliberately vague, and what are the implications? The Internal Revenue Code, IRC, contains multiple instances of deliberate vagueness, most notably the failure to define the key term income. This omission leads many to presume that income means any receipt of money, a presumption unsupported by constitutional or statutory authority. Vague laws violate the Due Process Clause of the 5th and 14th Amendments. Citizens have a constitutional right to know the nature and cause of any legal obligation. When statutes are so unclear that individuals of ordinary intelligence must guess at their meaning, the laws are void for vagueness and carry no enforceable weight. See Connolly v. General Construction Company, 269 U.S. 385, 391. 1926. What happens when a statute is found to be unconstitutionally vague? If a statute is deemed unconstitutionally vague, it is treated as if it never existed. No legal duty arises under it, and no penalties can be lawfully imposed. This principle applies equally to criminal and civil statutes, particularly those imposing financial liabilities or forfeitures. The IRS's reliance on ambiguous language in enforcement actions exposes it to constitutional challenges. When vagueness is combined with coercion, especially under threat of penalty or seizure, such actions may constitute violations of fundamental rights and are susceptible to judicial nullification. Has Title 26 of the United States Code ever been enacted into positive law, and what are the legal implications if it has not? No. Title 26, which houses the Internal Revenue Code, has never been enacted into positive law. This means that it is merely prima facie evidence of law and not the law itself. In legal terms, positive law titles are those enacted by Congress as definitive law. All others, including Title 26, are considered unofficial compilations. IRC Section 7851A, 6A, states that Subtitle F of the Code shall take effect on the day after enactment of this title. However, the term "this title" is undefined. Because Title 26 has not been enacted into positive law, the enforcement provisions in Subtitle F, governing penalties, collections, and summons, have never taken legal effect. How does the lack of positive law status affect enforcement? Without positive law enactment, Subtitle F lacks statutory force and cannot impose legal duties or penalties. This omission renders many IRS enforcement actions jurisdictionally defective. Courts are required to apply the positive law standard when adjudicating disputes involving substantive rights and obligations. The U.S. Supreme Court in Connolly and subsequent cases has held that statutes failing to meet the positive law standard cannot create enforceable obligations. In practice, this undermines the IRS's authority to compel compliance or penalize noncompliance, especially in the absence of clear, enacted law. What federal courts are authorized to prosecute income tax crimes? The answer depends on which type of federal court is being referenced. Under 18 U.S. C. Section 3231, only district courts of the United States, DCUS, which originate under Article 3 of the Constitution, have general jurisdiction to hear federal criminal cases, including alleged violations of the Internal Revenue Code. In contrast, United States District Courts, USDC, are legislative tribunals created under Article 4's Territory Clause. These courts operate in federal territories and possess limited jurisdiction. The Supreme Court confirmed this distinction in Balzac v. Puerto Rico, 258 U.S. 298, 312, 1922, holding that USDCs are not constitutional courts and cannot exercise the full judicial power of the United States.